everyone, welcome back to today's video. I, Shrishti Mishra, legal intern in LEXCLIQ and Company, is going to present today's unit topic, that is dying declaration. So, in this video we will be dealing with one of the case, that is in this case where the husband and sister-in-law walk free for after deceased dying declaration failed to inspire the confident in a 30-year-old case where the Supreme Court explained the yardstick for admissibility for a dying declaration. So Supreme Court where bench of Naveen Sinha and Krishna Murari was made, and it was very difficult for them to find out the facts. They should accept this, or they should for the rejection should be there for taking all the facts of this case. So what happened, that court where the hearing of a case dated to 1991, where a married woman scrubbed to 95% of burn injuries. The case become very complicated because there was no eyewitness present at that time who can tell that yeah, we have seen this or we have seen that, ऐसा हुआ है ऐसा नहीं हुआ. There were no eyewitness present, and based its case on circumstantial evidence involving the dying declaration of the deceased. So there was a dying declaration which was present by the deceased there. So what happened, that it's vacillated between blaming the husband and sister-in-law. The deceased blamed the husband and sister-in-law both in coupled with the absence of any certificate by the doctor that the deceased was in a fit state of mind where she has made dying declaration. So while making dying declaration, she was in fit state of mind, she was in a state of mind in which she can give the dying declaration. So dying declaration, now where it has been written in our Indian that is law. So dying declaration, that is under section 32 of the Evidence Act, that is 1872, and the court held that it alone can also form the basis for conviction of its has been made voluntary and inspired the confident enough. So what happened, that if there is any contradiction, variation, creating doubts about its truthfulness, or if the accused is able to create doubt not only about the dying declaration but also about the nature, with regards to the nature and manner of the death, so there shall be dying declaration. The benefit of doubt shall be given to the deceased accused, and much shall depend on the fact of this case. So benefit of doubt is given, but still the much focus should be on the fact of this case. So court took note about looking at this case, facts of this case. What court found out, the first was that the statement of deceased was based on hearsay evidence that the deceased was set on fire by husband, and there was no reference to sister-in-law in this statement. Okay, सिर्फ एक ब्लेम किया गया कि that the deceased were set on the fire by the husband, and no reference or the sister-in-law was given in that statement, nor anything about dowry demand was mentioned in that statement, and this statement was hearsay. एक ने सुना और एक ने बोला, एक ने सुना. So this statement was based on this. Second statement which was made by the deceased, that deceased blamed sister-in-law. Statement was not signed by anybody. The statement was not signed by anybody, and the doctor who recommended the statement has not been examined. Okay, so जब उसने blame किया था, the doctor was also not being examined, and plus that statement was also not signed by anybody. This was the second statement. Third statement which was found out by the court, that this statement was recorded by assistant sub-inspector blaming sister-in-law along without any allegation against the husband. Okay, blame किया उसने sister in law का, but against any allegations for her husband. So this was the contrary statement. Okay, first में उसने blame किया that I was set on the fire by the husband, and second she is saying blaming the husband and saying that कोई भी allegation नहीं खड़ा किया for the husband. So this was the contrary statement, and she was brought to the the point that the husband it's again does not disclose any dowry demand. Okay, dowry demand फिर से कहीं पे जिक्र नहीं करी गई बात की, तो this statement also went half rejection की तरफ जाने लगा. After that what happened, that 4 statements was made out also, where the assistant sub inspector stated that at the time of recording the dying decision, the deceased was in fit state of mind to make this statement, but no evidence about the fitness of mind of the deceased to make the dying declaration was presence of there were no presence of any doctor, and the truthfulness of dying declaration remains suspect till now. 30-year long case, imagine that, 30-year long case, still it has been in suspect. No judgment has been found till now. So this is about dying declaration, a case study of dying declaration where the bench of Naveen Sinha and Krishna Murari was made out. So this is whole about the today's video, dying declaration, a case study. So I believe that you find this video useful. If you find this useful, go and smash the thumbs up button, subscribe to the channel, and let me know feedback in the comment box below down. Till then, take care, goodbye.